Okay, to pinpoint the maliciousness of Rachel, the retaliations monster, we have to know what is actually happening in reality and then what she is leaving out of the situation and what the law is and what the possible ways of breaking it are. So this picture right here, not the actual picture, but my screenshot of it is an image of a digital record. It is a publicly available image that I have made a digital record of. Okay. If you make a digital record of a image that is been published, then there's nothing wrong with redistributing it, as long as it's edited or whatever, as long as you don't fuck with it. Now, Rachel knows this, but in the beginning, they're trying to play off the fact that people don't know this. So they think if you share this on the internet, that there's something wrong with it. Well, she has abandoned that idea. And now she's saying that because the information on it that the university put there, she's saying that information is what is targeting people to call Shannon Walker. Not because of what Lane said, not because of whatever, but because that her number and name and email are on there, but that's the reason that people are targeting her, right? Is because of the information contained in the digital record of a publishing that the Arizona University made on the internet. Now, this is one of the felonies, the videos that he made, that he put up on his YouTube page that they say is a felony, right? This is the video, the beginning of it, right? And then I'm going to explain something that's even crazier about it. But this is February 22nd. This video, this alone, is a felony, is what they say.
Going through this, I'm working on my appeal brief and stuff, memorandum, and I thought it'd be interesting to show this video how it's blatantly obvious that the perjury, the lies, it's all right there for the whole world to see. So I figured, since I'm going over this with my case, I might as well break it down. So as we can see, an injunction for harassment in the state of Arizona requires a series of acts over any period of time. That was a series of acts over any period of time that is directed at a specific person that will cause a reasonable person to be seriously alarmed, annoyed, or harassed, and the conduct, in fact, seriously alarms, annoys, or harasses the purpose. And here's the key: serves no legitimate purpose. First Amendment protected activity always serves a purpose. You can see an injunction for harassment in the state of Arizona requires a series of acts over any period of time. That was a series of acts over any period of time that is directed at a specific person that will cause a reasonable person to be seriously alarmed, annoyed, or harassed, and the conduct, in fact, seriously alarms, annoys, or harasses the purpose. And here's the key: serves no legitimate purpose. First Amendment protected activity always serves a purpose. Because I left her one voicemail, that would fall under electronic communication, and that section does not apply to constitutionally protected speech or activity or any other activity authorized by law. So she's a public official, a public employee of a public university with a public website with a publicly listed phone number and email. Therefore, she's a matter of public interest. And therefore, I called and left one voicemail, which we'll listen to now.
You have reached Shannon Walker, Director of Special Projects at the James E. Rogers College of Law. Please leave a message and I'll call you back as soon as I have a chance. Thanks.
Hi, my name's Lane Myers.
He leaves a callback number. Remember that. He leaves a callback number.
520-771-2021. I see you're Director of Special Projects. Well, I'd like to ask if you could approve a special project where you help me end your husband's career for being a crooked-ass cop, prosecutor, wannabe, whatever he is, hiding these cops from prosecution. I figured the U of A, maybe Stacy could help me. Maybe I should talk to you or Stacy or maybe one of these. Because, you know, my wife also is an alumni of the College of Law and is actually has taught there. So, like, we got two sides that are about to come crashing together here. So, you can help me teach your husband how to follow the law, or I'm going to take his career. So, I figured since I'm a member of the community and my wife's an alumni of the law school, that maybe I could get access to the materials at the law school in order to fight for justice, since Stacy's all about justice. So I guess I got to call Stacy next. So that was my one phone call. I made one phone call to the publicly listed number, Director of Development. She was the Director of Special Projects. But as you can see, no secret website, University of Arizona, right on the website, publicly listed. All I did was call that number right there on this public. So I called the number. So as you heard so look, case law says evidence of a single conversation between alleged harasser and alleged victim did not satisfy the series of acts. At a minimum, the series of acts condition of a statute authorizing requires two incidents. Injunction against harassment, which prohibited alleged harasser from any in-person contact, was unconstitutionally overbroad because of its infringement of alleged harasser's constitutional rights to free speech. Alleged harasser was restrained from engaging in political speech in alleged harassment victims' presence. Statute authorizing injunction against harassment cannot be used to restrict protected political speech.
Okay, so that's February 22nd. Now, rewind to November 15th of the previous year. So remember, it said the statute cannot be used to restrict political speech. Now, before this is his appeal brief he's working on, and he's appealing the decision that Brendan made. And in Brendan's courtroom, Shannon Walker said this 5 months previous to him drawing up this appeal brief.
From posting any messages or content regarding the plaintiff via any social media platform. That strikes me as broad and probably too broad for constitutional First Amendment type issues. So I'd like to hear your thoughts on that and whether it could be narrowed in a way that would make it constitutional.
So to your question, Your Honor, harassment is conduct, not speech.
Remember that too. Harassment is conduct, not speech.
I have copies of Arizona Court of Appeals cases, State v. Brown from 2004 and State v. Snyder from 2024, further explaining that if the court would like to review those. I'm not asking the court to restrict Mr. Myers' speech on political matters or general topics.
Think about this. She goes into an injunction against harassment, right, because she's so alarmed, annoyed, and harassed by this guy. But she brings Court of Appeals cases that are directly on point with what the possible issue is going to be later down the road whenever he thinks about it, right? That's insane, dude.
But Mr. Myers has harassed me personally and posted videos about me on his YouTube account. In those videos, he has posted my place of employment, work email and phone number, and office number, and asked his online followers to harass me as well, which they have done many, many times. Thank you.
Do we even remember what the question was? The question was, how can the unconstitutional restrictions that are on that petition or whatever it is, how could they be narrowed to fit? And she ends with saying, his followers have harassed me many, many times. Think about that, dude. She's asked a question about the Constitution, and her answer is immediately answered with criminal activity. Just remember that. So the reason they're doing this is because he knows the Court of Appeals is going to be reading this off a transcript. And if you look at it like a transcript, when she said if the court would like to review those, and then just immediately started talking about something else, it kind of, on a transcript, that'll look like there might have been a discussion between them, or some kind of off record or whatever, or some kind of break, or at least some thought about it. But really, she's just saying that for the record, so it's on the record that Brennan had a chance to review and then make an informed decision. When really, you know what I mean? She just kept going on with the sentence, but it's gonna look as if, because she said if the court would like to take time to read that and then period and then go to the next entry. You know what I mean? An hour could have went by. Him been reviewing that case when really it was a second. But anyways, it's all for the record, dude. They're doing this all for the record. She cites the case and then says whatever she wants afterwards, regardless if it fits or not. Because Brown, we're gonna go over Brown. None of it fits, right? And there's a really important part of it that's hilarious to me. But now in the same hearing, when Myers tries to read quoted directly from Cahill versus Alfaro, the judge cuts him off. See, I think her saying that Brown case out loud was a mistake, but there's not a mistake that it was in there, but a mistake that she said it out loud. I'll explain later. So what Matt Walker is doing is using the knowledge of law that they all have because they all went to the same school, the knowledge of the law, and communicating that way some people are going to get it, some people aren't, I don't care, but I know for a fact this is happening. So we have to look at Matt's previous course of conduct, right? His course of conduct is to do the witness victim witness victim confusion, right? And that's what he did to Mr. Myers. So anybody out there who is listening and that works in a kitchen, a serious kitchen, not like a McDonald's or something, a real kitchen, right? If you work in a real kitchen, you understand when I say this, that a waitress comes up and says, "Oh, my table 15 is allergic to whatever," right? Okay, you guys all know what that entails. You guys know every single one of you is going to have to do something, and every single one of you is going to be pissed about it, and it's going to fuck up your rotation. And we all know this, right? We know what's going to happen. We'll see. So then you go tell the waitress to go tell the table it's going to be like 30 minutes longer than they would have normally waited. You know what I mean? And they're like, "Oh, okay," well, then they're okay with it, right? Well, the thing is like they don't realize what's really going on back there is you have to change the oil, you have to change all the anything that's an onion is touched, you have to get rid of and get new product there, right? And the thing is, it fucks everything up, fucks everybody up, right? Now, some people, if you tell them it's going to take a little bit longer, and they're willing to wait for it, right? And because of that, right? And so we all get that. And some people are assholes, some people really have allergies, whatever. But what's fucked up is, what if I told you all that and made the whole kitchen do all that, and everybody else unknowingly went through all this extra work, and the person had to wait forever, but really I had already had whatever it was ready right here that had never touched an onion and had no onions on it, just sitting here waiting and doing nothing. You know what I mean? Like that would be fucked up, right? So now let's say the waitress makes the decision on her own that this person is lying about being allergic, or she overheard them say it, and they just said that they're allergic because they just don't like onions, right? So on my ticket it'll say no onions, and then the ticket will say on the fly, right? So I'm like, okay, I got to get this out quickly, but it says no onions. But it says allergy, but she'll come up to me and verbally say they don't mind waiting, right? So right then I already know what's up. But verbally she tells me they don't mind waiting, but the ticket says to hurry up, and she says they're allergic, but it says no onions. So I know right then, I don't have to go through the normal procedure for somebody who has an actual food allergy. But that's based on her. I'm basing all this on the fact that she properly diagnosed the situation as the guy just being a dick and wanting his food to have no onions, but still coming out at the same time and not waiting for the proper procedures in the kitchen to go through, so he'd have to wait, right? Because that's what people do. And I rely on her to make that decision, and then that affects me, right? Now, again, looking at this from an outside perspective, or not knowing what I have to go through, or not knowing that, like, our little language or whatever, people would think that it's fucking crazy, you know what I'm saying? But the courts, it's the same way, man. Like, it's the same type of communication with the same type of knowledge. You guys don't know what's going on in the kitchen, but I do, and we don't know what's going on in the courts, but they. Now, judges, people who've been to law school understand those certain things and can play off of them, and that's what I'm going to try to illustrate here. Because what seems like stupidity on Matt the retard, Matt the moron, what seems like stupidity and something that's moronic on his part is actually a strategic plan, right? That's why the stupider they are, really the more devious they are. But anyways, and what he does in his course of conduct is to use this and have the judge make the decision upon the one that he should have already made. You know what I mean? That he's leaving unclear, right? All right. So for example, the victim witness thing, right? Okay. So I'm going to play that little part of the video where I kind of think I still think he's retarded, but I'll show you why it's not retarded and why his course of conduct is so bad, right? So here's this part of the video, and then I'm going to put it in green, so whenever it comes back to, now, then that way you'll know. But this is the video that I made, or a part of a video that I made about Matt's course of conduct.
Under the penalty of perjury, that this man is accused of these crimes and we have probable cause to move this case forward. Well, what just happened was instead is I went down there, your little buddy, the prosecutor, refused to talk to me, and I've been asking for disclosure for 4 weeks, and he refused to talk to me.
That's the first part. Dodge, delay, deny, whatever. That's the first part, is ignoring. And of course, he's going to have a court order that says you can't go visit anybody that's ignoring you from the courts.
And then when I got in front of the judge attempted to move forward with an arraignment that lacks probable cause. The judge had no police report in his hand because you don't have a police report in your hand because they haven't given it to you. So the fact that you allowed an arraignment to move forward when at the moment that my arraignment took place, you will now need to testify in federal court under oath in a deposition how you felt under the law as it's written, ARS, you felt you had probable cause to move forward with charges when you don't even have a police report. And then I'm holding an order that says no contact with any victims. Who's the victim? Name them. Put a name to a victim. There's no...
You may also experience shooting pains in your pelvic and crotch area. This can feel a little bit like electric shocks, and it's known as lightning crotch in the birth world.
Victim.
I do have the name of the person that is the named victim. Just one moment. I'm going to look at...
Good, because I can get that lawsuit against him going.
In our file, and I'm opening up the police report, and I'm going to look under what the police designated as a victim.
So you have a copy of the police report?
I do.
Why wasn't it at my arraignment?
Jordy, I want to, sir, as long as you let me answer your question, I'll be happy to answer your question. But if you don't let me answer it,
go ahead.
I'll let you talk yourself.
Go ahead.
Jordy, Jordi.
Sweet.
Amador Perez. So Jordy.
So see, that's MJ Racidi. That's what Matt Walker's co-prosecutor is, right, on Lane's case on the O'Reillys. She says Jordi Amador Perez is what the police report says is the victim, right? So we know the police didn't do this, because if the police did do this, it would say what she's reading is something else then, because it would say police, victim, Jordi, and O'Reilly's building. You know what I mean? But no, the prosecutor did this, and they anyways. And just a quick question on how stupid that is. Like, a lawful representative of a building. You're a lawful representative of any building that you're standing in, or what? Does that mean she can go into court and make arguments for this building? Come on. And this is the reason all the businesses in Tucson better be scared, because if Matt's doing this to everybody, think about if he actually brought civil litigation against O'Reilly's and this document existed, listing this girl as a lawful representative of the building. Dude, lawyers would have a heyday with that shit. Civil litigation lawyers, oh my God.
First starting off with speedy trial.
As defendant requested a continuance, and he's a second charge arose from returning to the incident. No, it arose from them fucking yelling and flipping me off when I went by. It is not clear why defendant would return, because I can.
Well, we're just going to say Matt's version of this is the truth, right? Okay, defendant's second charge arose from returning to the incident location. It is not clear why the defendant would return there if they were unable to help him the first time. Okay, think about that. If you were unable to get the part that you needed for your car, it is unclear to him why you would return. I'm just going out on a limb, but probably to get the part you needed the first time. In fact, I think that is the only reason to return, because if you got the part you needed the first time, you wouldn't need to return. Now, that would be unclear. If you got the part you needed and then returned, that would be an unclear thing. But if you didn't get it the first time, it's damn clear. You came there to go get it. What a fucking idiot. Also, it says that In any event, defendant freely admitted returning to the location, blah, blah, blah. He also consistently fails to demonstrate any understanding that O'Brien is, in fact, a victim in this criminal matter.
I do have the name of the person that is the named victim. Just one moment. I'm going to look at.
Good, because I can get that lawsuit against him going.
In our file, and I'm opening up the police report, and I'm going to look under what the police designated as a victim.
So you have a copy of the police report?
I do.
Why wasn't it at my arraignment?
Jordy, I want to, sir, as long as you let me answer your question, I'll be happy to answer your question. But if you don't let me answer it,
go ahead.
I'll let you talk yourself.
Go ahead.
Jordy, Jordi.
Sweet.
Amador Perez. So Jordy.
First starting off with speedy trial.
As defendant requested a continuance, and he's in any event, defendant freely admitted to return. Yep, I surely did, and I didn't commit any crimes, and I'll never be convicted of it, and they'll never find me mentally ill, you fucking moron. Defendant has also consistently failed to demonstrate any understanding that O'Brien is in fact a victim in his criminal matters, again to his legal detriment.
Again, dude, this is magic fun mirror crazy clown circus world. And literally, he even says right here, he says Sergeant Daniel Deloria listed O'Brien as a witness. Another one reported by Jamerson disclosed to the defendant that she clearly is a victim. Oh my god, dude. Matt is insane, bro. Okay, and you see, here's the part that tells me what he's doing. See, he puts the definition of the word victim against whom the crime has been committed. Now, the very next words need to start out just exactly like the decision in Brown do. It starts out with, after a jury conviction of blah, 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 for blah, 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 then Jordy and whatever. Okay, and here's where the psychology comes in. The judge knows that victims often feel unsafe. And then if Matt puts the definition of victim right in front of it, even though those two people are not victims and in fact are even listed up here as witness, one of them as a witness, the judge is still going to put those together. And Matt knows this bullshit, and that's his MO. The reason that you disclose this information within the 30 days or whatever for trial is so they have this information and you can stick with it, because within those 30 days things do happen. Like, for example, and here's the thing that people who don't go to law school or don't know is that the prosecutor, Matt, can change those, right? He can list that there's the named victim, the listed victim, and then the victim for like financial purposes or whatever, right? So he can literally, you can be a victim on the police report, but be a witness at trial. So it can be Mackenzie O'Brien, listed victim, but or named victim, but listed witness. You know what I mean? Or whatever, the other way around. You know what I mean? But that's why you turn over the initial disclosure, which is a police report, and then 30 days later, whatever the time period is, you give Mr. Myers a list of what these people are going to be at trial, so he can prepare that way. Here's what slime balls do with all that information and power that they get to pick these people and stuff. Now, this fucking moron Matt, this fucking piece of shit, has taken it a step further, and he's used victims' rights, which is, for example, part of it is, let's say you're a victim of crime, right? Not a crime victim, not like the crime was committed against you, but a victim of crime, like a pawn shop that got a broken window because somebody stole a bunch of shit. Well, they can't get the money from the insurance for the broken window, but they're a victim of some fucking crime. So there's crime victims. So a building can be a victim, right? Not a court, but a building can be a victim. And a legal representative can represent them so they can, find out what's going on with the case and be like, for the civil side of it. This is for the civil side. If they're a building victim for civil litigation purposes, that doesn't mean that the lawful representative is a victim in the criminal case, right? So, and also too, like what happens if you got hit by a car and you get knocked out, right? You're incapacitated. Well, there's a provision for that too. What Matt fucking the slimy shitball Walker has done is he has taken that whole, that idea of that part of the law and applies it to shit like this, right? So what he'll do is he'll fill out the part that says incapacitated. So the victim is incapacitated because it's a building, right? So O'Reilly's Auto Parts is the building is the victim. The building itself is the victim of a disorderly conduct, right? But he'll set what he wants to be the victim, Mackenzie O'Brien, as the lawful representative of that victim building, right? And then that's how he'll do it that way. So if anything, it's fraud on the court. I mean, But it explains perfectly that his misunderstanding, like he's putting the building as a victim, a person against whom the crime is being committed, right? The building's not a person, so that can't be a victim, right? They can accept, like I'm saying, you can in certain circumstances, but he's calling, in this case, he's calling the building a victim, an incapacitated victim, and then putting Mackenzie as the lawful representative, who is an actual person, right? But again, this is all. Now let's pretend in the real world that something like this were to happen to the building. The lawful representative of the building would not be the person injured in the building. The lawful representative of the building would be a person that is defending the building against civil litigation, like a lawyer, a high-powered lawyer. You know what I mean? This is what confused Mr. Myers, because he thought that meant she was a minor. But if you were a minor, if she was a minor, why would the building represent her? Wouldn't it be her mom, right? Like somebody who can make legal decisions on her behalf, just like a building would have a high-powered lawyer. So that's how you know it's malicious. Or just remove all the other words. Like, for example, it would read rights revoked. Rights invoked by representative of incapacitated person or business. So if you just remove the word rights invoked for business, then it's rights invoked for incapacitated person. So the victim is going to be represented by the victim, right? If building wasn't an option, if it just said rights invoked for incapacitated person and it said Mackenzie O'Brien, so the rights, she would be incapacitated and representing herself, right? Think about that. You see, these rights are statutorily for buildings, they're statutorily automatic. You know what I mean? If the incident location is that building, then they get these civil the rights for the civil side of things if they need them, right? You don't have to use something, invoke the rights on a piece of paper and write it down unless you're a person that is incapacitated or you're a minor, right? For a building, you don't need that. You know what I mean? But he's using that function to do that for a building. Dude, think about what he's done, dude, or what they're doing. So you get arrested for like domestic violence or something or whatever. You go to the court. Now you're ordered not to go anywhere near the person, right? The witness or the victim or whatever. You don't even know. You know what I mean? But you're ordered not to go anywhere near there, not to have contact with any of the court officials, not to be able to contact any of the court clerks or anything. So you can't do anything on the legal end of it. You can't get a hold or talk to the person who's accusing you of it. And then if you do, you're either contacting the victim or it's witness intimidation, right? And then if you try to tell the court anything or explain your reasoning for, even if you try to preemptively stop that and tell them you're going to go see her, just getting a hold of the court officials to let them know that you're going to go do this, respectfully and lawfully, is a crime in itself. Literally, if you are arrested and brought to court in Tucson, then you will not get a fair anything, right? Because even if they grant the officers interviews or whatever, like you still have to get a court order to get any of their information. They've created an environment and a situation, a system where it is impossible to assert your constitutional rights for a fair trial, for equal opportunity or equal treatment under the law. And now they're silencing the person that's outspoken the most about this for Tucson City Court, 15,000 followers or whatever they say, right? Mr. Myers is the biggest voice of all of us that are getting fucked by these people, and now they're using him as an example and silencing his speech to silence all of ours, so nobody finds out about this. That's what's happening. Anyhow, I'm sorry about that. Back to what I was talking about. So we know that Matt does this with the judges and gets the judges to decide and gets them to use their legal knowledge to make their own inferences, right? So I think with the whole Brown versus whatever 2004 that Shannon brought up, was the very first part of that case says that the appeals court did not look at anything that the petitioner, when he got the petition for the injunction, they just accepted that. They didn't look or re-go over any of that hearing. Of course, it's only a footnote, but it's the number one footnote. It says the propriety, like the proper, holding of the injunction against harassment issued by the city court is not at issue here. See, I think she was supposed to submit these, and when the first thing Griffin was to read was going to be that, and he's going to be like, oh, well, nobody's going to look at it. And then he looks at the other one, and he's like, oh, well, people have already thought that this is possible, so he's already got a goal, you know what I mean? And Matt did this on purpose, or had her do this on purpose. There's no reason to talk about case law or to involve any case law before you start talking about the merits of what's in front of you and applying the actual statutes and law. There's no point in reading case law first. You know what I mean? His job isn't to figure out the part of the case that his job is just to say that there's evidence that there can be a case. You know what I mean? That there is evidence, reasonable evidence of some kind of harassment. You know what I mean? Not that that's only his only job. He doesn't need to know the case law, because why would you present case law to a judge that isn't judging any merits of the case or any details of the case other than the fact that there might be some evidence that says that he's guilty of harassment? The specifics of the case are meaningless to Griffin, or should be. So, you know what I mean? And I think that was the only reason for this existing in whatever list of papers that Shannon was reading out loud, and she wasn't supposed to read it out loud, because if you look at Brown, it actually, if I were to go to trial, or if I were a appeals court and I looked at Brown, that's what I would use to decide that what the court erred in this case. This is what I would use to prove Rachel wrong, is this case. And the other one she cited was State v. Snyder, and Snyder says you can't cite anything that's in there, but only use it as rule. And basically the whole thing around that case was that the court said that maybe it's not a far stretch out in left field or a stretch of the imagination to think that maybe possibly in the future somebody might be able to convince somebody that making calls on behalf of a YouTube video could be considered harassment. It didn't, you know what I mean? So the two things that she offered were, one, something that didn't happen, and then two, something that the Supreme Court thought possibly could happen. Now, how did this case end up in a completely different, you know what I mean, the conversation in a completely different courtroom, in a completely different, how did it go from Matt Walker to being discussed in front of Parvin and Metcalf, right? And then Metcalf having the exact same misunderstanding. Listen to this. First, you remember earlier when I said this? She's asked a question about the Constitution, and her answer is immediately answered with criminal activity. Just remember that. Now, here's Metcalf talking about the Brown case.
The Brown case says criminal liability.
Okay, so this is English 101. He just said criminal liability, right? What is the subject of this sentence? What is everything in the sentence going to be about? It's going to be about criminal liability, right? Okay, I'm going to start it over, but just remember that. Those first words were in Brown. It says that criminal liability.
And if you look,
So let me. The Brown case says criminal liability under the statute is based on the manner in which certain communication is conveyed and the underlying purpose for the communication.
So based on that, what do we think criminal liability is? It's the manner in which and the underlying cause of which, right? So the subject and then the two factors are what it is. And this, I'm going to start it over again and hear what Metcalf says.
The Brown case says criminal liability under the statute is based on the manner in which certain communication is conveyed and the underlying purpose for the communication. So they're saying that's why it's constitutional.
What? What the fuck? No, that's not what it says, bro. It says criminal liability is based on those things. That's what so they're saying that's the criminal liability. It has nothing to do with anything constitutional. They're saying just the opposite. They're saying the constitutionality of it isn't even a question because of those two factors being so specific. They think a constitutional argument or a constitutionality of something or a constitutional claim is a defense against an actual crime that absolves you of it. It's not. It's to explain that it never was a crime in the first place. They don't understand that. Almost all statutes are unconstitutional, right? And the reason that the Constitution and the constitutional arguments don't belong in little stuff like this is because if the constitutionality of it should not be a factor if it's charged properly and the elements fit, right? The fact that they're bringing up the constitutional issues mean that it's either the statute is bad, which it's not, or it's improperly being applied to the person's specific facts, right? How can you be so wrong about something? And I can't stand these people. Anyway, I'm moving on. But so anyway, I'm just trying to show that, for example, okay, Matt Walker, right? His pattern of practice or whatever is to confuse everybody to the point where he needs clarification. I mean, we see this in that 122H arguments that he made, right? His whole thing was, it's just unclear what it says about the recording and the broadcasting from in the pocket, when it literally says you do not need permission if it's on your person to record in your pocket. It cannot be any more clear, but he's trying to make it so it is unclear so they can rule in his favor, right? And the same thing with the victim, the witness thing. They made it so unclear that they had to declare somebody mentally unstable so he could put it in a motion so the judge can make his decision on it, right? Again, it's something that is very, and he tried to obscure it by saying, oh, it's unclear why he would show up if he didn't get what he wanted. You know what I mean? When obviously he showed up to get what he wanted because he didn't get what he wanted in the first place. So that's his MO, right? And it's the same thing that's happening here, but the problem is they're trying to apply a way of thinking that it is wrong. You know what I'm saying? And Mr. Myers sees this and knows this, right? Having knowledge of what's going to happen in a certain hearing, or what a certain group of people have a duty to do something. If your actions are based on what that outcome of what they might think is, it's going to change your actions. So just watch this little thing real quick. They convened a group of professionals, they say, to prove that this horse could do math.
At the beginning of the 20th century, a horse in Germany rose to fame as he knew how to count, add, multiply, and divide. This created a stir throughout Europe, and people could not believe how impressive it was. At Animal Wised, we show you the secret of Clever Hans, the mathematical horse. Clever Hans and his owner, Wilhelm von Osten, were dedicated to giving shows so that everyone could see with their own eyes that this horse had exceptional qualities. Von Osten would propose an arithmetic question such as what is 7 times 2? To the amazement of the public, Hans would kick his hoof 14 times. To ensure they weren't cheating, members of the public would ask mathematical questions, and the horse could answer those too. Clever Hans became very famous, so much so that he was featured on the cover of magazines and newspapers. He became famous outside his native Germany throughout Europe. It was at this time the German government became involved when they appointed a commission to verify the horse's ability. The commission's group numbered 13 people, including a circus manager, a zoo director, a veterinarian, a cavalry officer, and a psychologist, the latter named Karl Stumpf, who assumed directorship of the group. The report developed by the Hans Commission concluded that the shows were real and there was no deception of any kind.
Did you hear that? A psychologist like Shannon, a zookeeper like Matt, a clown, circus performer. Okay, but you get that. A bunch of professional-minded people all got together and said that there was no deception.
However, a Stumpf aide, another psychologist known as Funkst, realized that Clever Hans was only correct in the answers that his owner also knew.
Stumpf aide, basically a fucking horse manure, horse shit picker-upper. One person that worked on the picked up the horse's shit noticed that.
After numerous experiments, he found the horse only responded correctly 90% of the time, and only when the owner knew the answers. When von Osten did not know the answer, the horse was only correct 6% of the time.
Or, in other words, never.
Upon discovering this, they decided to remove the owner from the experiment and achieve the same result. When the questioner knew the answer, the horse knew it also. When he didn't, neither did Hans. The reality is that Clever Hans did not know how to count, but was an expert at reading the body language of others. This was both surprising and proved his intelligence, even if it didn't include arithmetic. As long as the audience, the questioner, or whoever was present didn't react, Hans would keep kicking the ground. However, when the correct number approached, the audience's excitement increased and Hans would stop when the tension reached fever pitch. In experimental psychology, this is known as the Pygmalion effect, also as the Clever Hans effect, named after this clever horse. The Clever Hans effect refers to the influence that a researcher's expectations will have on the result of their experiments. This is because subjects often respond in the direction expected of them.
Wait, one more time with that, what'd you say?
This is because subjects often respond in the direction expected of them.
Judges often respond in the direction that they think is expected of them. I know he said subjects or whatever, but in this case, it's judges. They respond in the direction that they think they're supposed to. Right? So if the first thing you do is offer some case law about some, whatever possible thing that may have happened that the Supreme Court already said could happen in the future, and that's the first thing, and then you get to hear all the arguments, you're going to be leaning toward that, bro. And Matt knows this.
Although it turned out that Clever Hans did not know how to solve mathematical equations.
Really? He didn't know how to solve mathematical equations, and that whole group of professionals didn't know any better. Weird.
He was an incredibly intelligent horse. How incredible does he seem to you?
Okay, see that right there proves that this is such a mindfuck. But he just said the horse is incredible. How incredible does he seem to you? What the fuck are you talking about? Incredible? He doesn't seem incredible at all. Everyone else around him went full retard and convinced themselves that he's magical and can count and stuff. There's nothing incredible about the horse. The horse has stayed the same horse he's been since he was born, and every other horse like him. What's incredible is the idiocy of the people around him, just like in the Myers case. Actually, what's incredible is that the people that just watch this and they're like, that has nothing to do with this and blah, blah, blah. This was 100 years ago. They had this knowledge that people are, swayed toward a certain, ending because of whatever. And those of you laughing, you guys are probably the people that believe that a dog can go around your car and smell drugs, right? Yeah. See, instead of having the knowledge and implementing that, we just play and allow people to believe certain things, right? This knowledge was available 100 years ago, yet we still let dogs dance around our cars and fucking sit down and then expect that is a reason that there's narcotics in the car. I'm giving you a fucking break, dude. The point of this is that the point, you have to know what your job is or what your purpose is as a judge and as for each hearing. Griffin's only job was to decide if there was reasonable evidence of harassment. That's it. Now, look at all this stuff that's going to be on the record that he had no business finding or whatever, no business even saying. All he had to do was take in the evidence and say, and by affirming the injunction, that means that all he's attesting to is that what he saw is reason to believe that there is evidence. Not harassment, but there's evidence of harassment, right? That's his only job. Now, look at all the shit that he found.
Mr. Myers, when that video was playing, it seemed like you were trying to hold back laughter, and then you kind of raised your fist up as if you were supporting the comments that were in that.
So now you have a judge that says that if you just read it on a piece of paper, that Mr. Myers supports those comments. You know what I mean? He doesn't, but it's on the record now that he does. Okay, and when they make the transcript, type out the transcript, it's going to say objection, and then here's the objection.
It's already been admitted, so...
Well, I have different videos, too.
What exhibits do you have that are different?
A recording of the hearing with her husband where he asked for the same thing and got denied.
Why is that relevant?
Because her husband, before this injunction was issued, her husband tried to get one for the same reason and a judge denied it.
All right. I'm finding that's not going to be relevant.
No, for her. He tried to get a court order. Listen, maybe I failed to articulate myself properly. Listen, the case she referred to about him prosecuting, he came to court and asked the judge to issue a change of conditions of release that I couldn't contact his wife or make videos about his wife or say anything about his wife. And the judge looked him straight in the face and said, he's a news reporter. It's First Amendment activity. I can't stop him from doing that. He's not breaking the law. So what they do, they went over to Judge Walton and tried the same thing that they just got denied with the day before.
All right, that's not relevant for what I'm doing here today. I'm my own judge. I get to make my own decisions on it.
Another judge denying it is not relevant?
Doesn't bind me right here, right now.
So you're denying my exhibit?
Yes, I don't think that one's going to be relevant. Do you have another one?
Now, a judge can find if certain things are relevant or not. Now, he found everything he just said to be irrelevant, even though it's like detrimental to his case. But none of that will be on the transcript. It'll say objection overruled, or judge found irrelevant. It won't be what we just saw, or they won't be able to read what we just heard. You notice how the judge is real adamant about him saying the word objection, right? Now, listen.
This is not on the paper, sir. It's not on here.
What's the objection?
This is not on here.
You said this.
These phone calls were not mad. These were not on the petition. Nothing about other people calling her are on this petition as an act leading to a harassment. This is all going off the rails. You're just, where's Deborah? Show me Deborah Moore on the petition. Show me the name Deborah Moore on the petition.
Mr. Myers, what I'm hearing you say is you're objecting that the evidence is beyond the scope of the petition.
Of course. It's not even
So all the shit we just learned that Mr. Myers said, but the person's name is Deborah Moore. The judge is going off the script. Nothing that is reading is on the petition. But this is all within his objection. Well, the objection that the judge made him say objection to, right? But this is how the transcript is going to read.
You seem like you're getting angry. Your tone of voice is changing. In the videos, according to what you've seen, Mr. Myers gives your name and phone number.
Correct. My name.
Well, so now the transcript's going to read that Mr. Myers gave her phone number and her name, and that's what it's going to read. Also, too, notice how the microphone is right in her face, right in directly in her mouth area, right? And then notice how the judge, when the judge talks to her, he gets real quiet. But when he talks to Mr. Myers, he yells. That's going to be important later whenever all this comes out. Trust me.
My phone number, all workplace phone number, email, office number, encourages his followers to come visit me and says,
You know, she said work number, office number, like not distinguishing that the office number is just a number that was on the door that they took down. But office number sounds like she has a work number and a personal office number, which she doesn't, like a phone number. You know what I mean? It's just suggestive because if you hear one, you're like, oh, well, it can't be the work number. It's got to be an office phone number because you just said number. Like, it's so bad.
Any number encourages his followers to come visit me and says,
Oh, there we go. That encourages his followers bullshit.
anyone can come visit me. And obviously visited me himself.
She's talking about when he came down to her work when she wasn't there, but he never visited her. But if you read that on a piece of paper, it's going to look like he's stalking her, dude.
And does he say why they should come visit you?
So what did Mr. Myers say the crux of all this was the no purpose, right? No legitimate purpose. That's the whole crux of it, right? And this is 5 months before his diagnosis of that and finding that, right? So what does the judge? What does Shannon say?
No, my impression.
See, look how surprised Mr. Myers is and looks over at her. Everybody looks at her because she's given up until this point. She's given like 7 reasons.
No, my impression.
Why would she say no when literally on the petition it says that Mr. Myers claims I had his wife fired? And look. Why would she say no after this?
Impression.
I went to the meeting, got arrested for booing. I was being prosecuted by this city of Tucson. I filed a giant lawsuit against them. I made videos on my YouTube. It went to the newspaper, exposed everything that was happening to me about getting arrested for booing. The prosecutor in the case is Matt Walker. His wife is Shannon Walker at the University of Arizona Director of Special Projects. So a few months into the case, they were continuing to unlawfully prosecute me for booing. So I called Stacey Jane, who is the Director of Innovation and Access to Justice, right? She has programs for... So as one would do, they go on a public school website, see that, hey... And they get their number off the website that's listed, University of Arizona, James College of Law. That's a public university, public website. She's a public employee. I contacted her at the arizona.edu address listed. We exchanged emails. She said, I don't have anything to help you. Good luck, though. Tell your wife I said hi. Okay, cool. Fast forward 2 years, and now here I am getting with this booing thing, and... I called her and I said, hey, Stacy, remember we spoke about 2 years ago about some civil First Amendment stuff? And she goes, oh, yeah, I remember you. Of course I have all this recorded. That's why she's a fool. And so she says, yeah. And I said, yeah, I need some help. I got arrested for booing down at City Council. I want to see if there's anything you can help me with. But I said, but if you can't, I said, or... can you not help me because you're friends with all the prosecutors? Which they are. They're all friends. I didn't say that she's a bad person. I just said, or would it be a problem saying, hey, can you help me? Or would it be a problem because you're friends with all those people, right? And she said, well, email me and we can go from there. Okay, get off the phone. I don't email her. But about 2 hours later, my wife gets fired from her job as a law clerk for a federal judge about while she was being awarded a 5-year award for being the best employee. Within 2 hours of me calling Stacy Jane, she called Judge Zips over at the court, who she used to work for as her law clerk for 13 years, and told him that I called over there because the issue is Shannon Walker is Matt Walker, the prosecutor's wife, and I'm suing Matt Walker, and I'm embarrassing him all over my YouTube channel, and I'm exposing his illegal actions and all this stuff. So in a coordinated attempt to silence and take my rights away.
Okay, we all know how this one we get it. Okay, but you see what I'm saying, though, right? How the court record is not going to reflect what he just said, and how the fuck can she possibly, and dude, this was posted, how does she not get it? Like, she said no. Like, does he say why they should call you? No. Dude, this is like, again, he doesn't say why we should call because he never said that and he doesn't encourage it. But if one were to, call on his behalf, there definitely would be a reason.
It has been that it was all so that I could be intimidated and by extension my husband out of no longer prosecuting his case.
And from your perspective, is there any reason Mr. Myers should be having any sort of contact with you?
Absolutely not.
And have you ever told him to stop having contact with you?
We've never spoken. I've been afraid of him. But, Your Honor, I will add that Mr. Myers has never in any way indicated why he would reach out to me for any other reason. And he has explicitly stated it was because I'm married to Matthew Walker, who's the prosecutor, or was the prosecutor in his case.
Listen to how much louder he gets whenever he turns to Mr. Myers.
Thank you. Any other evidence?
No, thank you, Your Honor.
Mr. Myers, it's your turn to present your evidence.
How do you want to do it if it's the same thing she already?
You don't need to, it's been admitted.
So we can both use that? I can call up exhibit.
You can refer to it.
Live streaming right now, half of it. But the two main points are that by Mr. Myers live streaming right now, it's actually part of what has caused so much harassment for me, as well as others to shoot.
I'm listening.
Thank you.
So I do believe that that is a violation of the injunction as it's written.
Thank you. Mr. Myers?
I have copies of Arizona Court of Appeals cases, State v. Brown from 2004 and State v.
So they bring all this to Rachel and show it to her as evidence or whatever of what's going on. So she reads the transcripts, right? Because they're allowed to do that. So there's official transcripts and she's reading them and they look like this. So she thinks this is really what's happening, right? So then, listen, on the arraignment, she even says that they have the court transcripts.
The addresses of theirs online. And number 6 under 133967B is 6, weight of the evidence of the accused.
She said weight of the evidence. If you have strong evidence, what do you need the court records for?
The state has very strong evidence of all of his crimes in this case. He's been live streaming about them, so we have video evidence. We have his admissions. Just yesterday, he went on and went through every single charge, talking about what he did to commit those offenses. So the state has very strong evidence against him. And we also have the records from the court. And we also have the records from the court. And we also have the records from the court.
How could possibly records from the court, like the court records, be used to convict him? How can that be used? I don't understand. It doesn't make sense to me.
And then number 12, the accused record of arrests and convictions as previously.
Okay, so now still Rachel's burden is to prove harassment, right? So once again, let's hear Mr. Myers say what constitutes harassment.
Let's see. An injunction for harassment in the state of Arizona requires a series of acts over any period of time. That was a series of acts over any period of time that is directed at a specific person that will cause a reasonable person to be seriously alarmed, annoyed, or harassed, and the conduct, in fact, seriously alarms, annoys, or harasses the purpose. And here's the key: serves no legitimate purpose.
So Don Weiland and Judge Brendan Griffin, their only jobs at the end of their hearings were just to prove or just to find that there was evidence of this so-called harassment. Rachel's job is to prove through the facts and the evidence that there is actual harassment. See, their jobs, the first two's jobs, were not to find anything other than the fact that that evidence is legit, right?
30 seconds. I specifically received 2 calls and voicemails from Deborah Moore at 360-633-9136. The first voicemail is Exhibit 10. May I play this exhibit, Your Honor?
How do you know what it is?
It is someone that...
You listen to it?
Yes, I have. I've listened to it myself.
Recorded it off your own phone?
Correct. It came directly from my workplace.
She pauses for way too long. I'll replay it, but listen. She doesn't even say voicemail until after the judge starts talking. Listen.
Recorded off your own phone?
Correct. It came directly from my workplace.
Any objections to 10?
Of course. Who is Deborah Moore? I've never met her in my life.
The objection's overruled.
You see what I'm saying now? Objections overruled. That won't be none of... I never met Deborah Moore in my life. Won't be on there. And it'll just say, yeah, this is from my workplace email or whatever the fuck it was. And then it'll say played, whatever. And then it'll say... Now... How are they going to know that his voice was in the background? Oh, that's right, because she said, I would like to note for the court that you can hear Mr. Myers' voice in the background in one of his videos. Think about it, dude.
You can play, Exhibit 10 is admitted and you can play it.
Thank you. And I will note that you can hear Mr. Myers' video in the background of this voicemail.
See, they're trying to authenticate it, but they can't because Mr. Myers, they're not going to be able to get a hold of the person that sent it because, I'm the one saying, and you can take me to court all day on this. I'm accusing them of completely fabricating it because not only is it a person, the name Deborah Moore, a court reporter for Tracy Miller, one that was in Tracy Miller's courtroom the day of the hearing where they let in all the evidence, but also too, she even says, if you listen to it again, she says it came directly from my workplace. And then she pauses for way too long and then says email or whatever. So, and on top of that, it's the thing that ties this to him is the fact that the video was playing loudly in the background. I mean, come on. And that's still, let's say that this recording never happened, right? Rachel is still, that's what they're still trying to use to authenticate it because what she said was one of the guy was coughing and saying stuff or whatever, that he was specifically referencing the U of A because it's specifically referenced in the same injunction that he's been showing on his videos since he got it, that's the reason that ties it together. And also too, that her website information from the U of A is why too. Both things that have been public information since for years, probably for the U of A one, and then ever since the day of issue for the injunction. You know what I mean? Her address has been out there for since then. So it's useless. Plus she's married to a prosecutor, right? So, I mean, their address isn't protected. Now Rachel's going to pretend that this is so important that she has to violate somebody's rights to keep this address protected. I'm going to put it in green, but here's another one that I made a while back. So, yeah, it'll be in green. Okay, so this little exchange right here.
The victim and then her spouse, and their address is protected, so he doesn't get those.
Okay.
No, she needs to give me an address.
No.
He's a witness.
No.
He's a witness.
Mr. Myers, I'm not going to go down this.
I'm not looking for Matt Walker's address. What I'm saying is I need to be able to put out a way, because I need to do pretrial interviews with these people. So how do I contact them without their address?
You ask Ms. Stiles.
No, you do not go through the state.
No, you do.
You don't. I've been through this with Matt Walker. He literally told me.
You can file a motion on that. No, Mr. Myers.
State doesn't participate.
No. You can file a motion if you want to do it a different way.
Mr.
Myers.
State doesn't participate.
No. You can file a motion if you want to do it a different way.
Listen to this, okay? Don't question yourself on that, bro. In fact, you should bring it up again because this is what the state bar had to say to a petitioner who wanted to redact information unilaterally, right? Prosecutorial, unilateral, whatever. Anyway, here's the state bar's response to what this dude wrote. It was about redacting information like bank information, credit card fraud, and theft, and possible, whatever. He said in those cases, the information is relevant and critical to the prosecution and consequently equally relevant to and critical to the defense. Although disclosure is required under 15.5 provisions for protective orders that satisfies the state's concerns for protecting a witness's sensitive information. In sum, petitioner proposed rule modification creates an injustice to the overall integrity of the disclosure process. Unilateral prosecutorial excision of records substantially hinders defense counsel's duty and ability to conduct an independent investigation. The amended, as proposed, would require defense counsel to seek the court's assistance to conduct its investigation, thus, in turn, necessarily informs the prosecution of precisely what or whom the defense is investigating. The Arizona rules of criminal procedure do not limit the right of the criminal defendant to conduct an independent pretrial investigation. Carpenter v. Superior Court, 176, Arizona 486, 491, App 1993. And see, for a protective order, you need a relationship with the person, which is another reason why those cops accidentally put that in there, you know. And then of course she has to bring up the fact that the video, and he talked about it and whatever, but she couldn't get a protective order and can't because there's no reason for to hide her information because he's not a threat at all, and she shouldn't be scared of anything if there's no threat, you know what I mean? So she can't get a protective order. So but to make it believable, the only thing that Rachel can do is pretend that he's some kind of danger, and so to keep him in jail, right? Just to keep up the facade, keep it believable, which is another reason she said out loud, she said, I'm not going to be, I won't be comfortable unless he's in jail until trial, right? But again, there was never going to be a trial. So it might seem like I'm connecting some dots there, you know what I mean? You might think that I'm making a big leap toward this, but what if I had knowledge that nobody else did, that all she had to do to get her address removed or whatever, and probably has already done this, is just tell somebody, hey, I feel scared. Basically, they're saying that Mr. Myers is so dangerous and they have to keep the address from him and violate constitutional rights of his and violate his right to a fair trial and convince all the people in previous that she's scared for her life. What if I told you that she ghosted her address a long time ago? There's a program where all she has to do, literally since she got the injunction, she can just take the injunction and go make her address disappear. What would she have to be afraid of then, right? Nothing. So this is a program where government officials can, you're not going to believe this, have their public address, the one that they're supposed to be made public to hold the public office, they give them the address and then they make it disappear, and then they have this group of addresses that they get from the DPS, and then they give them a fake address, but it's like it comes back as a real one. This is crazy, dude. But anyways, there's certain criteria you have to meet, and right before this starts, this is legit because if you know anything about government, because it has every other stipulation every other government exception does. If you're afraid for your life, you can get it. And now for what everybody's been waiting for. Proof that Shannon Walker cannot possibly be afraid for her life reasonably. Proof. Reasonable proof. Okay, this was recorded over a year ago. I forgot I had to say that first. So it was out before any of this happened.
Cost for someone to enroll in this. No, there's no fee. Some states have fees that is provided by the confidential address program is to be used in place of a participant's home, work, and school address with all state and local government agencies. So those are the two components that each state's program has in common.
So let me ask. So if I was enrolled in this program, it wouldn't be like a PO box, or would it be? Or would it be an actual street address that I would give out?
Arizona's program uses a street address. We learned from other programs that some programs have PO boxes. PO boxes, you run into some issues, especially when it comes to state agencies and federal agencies that don't accept PO boxes. So when you use a street address, that actually carries over to federal agencies, which federal agencies are not required to accept the substitute address. However, if you use the substitute address, since it's a street address, if there's nothing preventing the address from being used, you can just use it and no one's going to necessarily question it. in Arizona, it's like an apartment complex, and the United States Postal Service actually provides us with a bank of apartment numbers and +4 zip codes that match a bank of apartment numbers. So these are actual addresses. If you look up the address on USPS's website for a zip code search, these addresses will come up as actual addresses.
And that's what I was thinking as you're explaining this, just how many times in everyday life I will see something that says, no PO box accepted. You have to put a street address.
Then, what am I missing? I'm missing something. Stalking. You must have relocated within the past 90 days. Once they do remember, then you have to go back and kind of look at that system and make sure it's updated to the proper thing. So it's redacting their actual address and updating with the substitute address and so forth.
So it sounds like it was quite a huge accomplishment and task to get this up and running, but the work hasn't stopped then, and it continues to build and evolve to keep this up and running and current. So is there a cost for someone to enroll in this?
No, there's no fee. Some states have fees for certain individuals, but our state has no fees for any individuals. As long as you meet the eligibility requirements, which are you must consider yourself to be a survivor of domestic violence, a sexual offense, or stalking. You must have relocated within the past 90 days or plan to relocate in the near future. And it must be the near future. It can't be 6 months to a year from now. It has to be somewhere within the near future. To a place unknown to the person you're seeking safety from, because it's not going to help you if the person knows where you're relocating to or knows where you currently reside. And then, what am I missing? I think I'm missing something. Maybe I'm not missing anything. But yes, that's, and they have to meet with an application assistant to complete their application into the program.
And you use the word survivor. So does there need to have been a conviction for domestic violence or stalking?
No, they do have to provide a piece of what is referred to in statute as evidence. They have to provide a piece of evidence with the application, but evidence is not like it has to be a police report. It has to be a conviction. Police never have to have been involved. They can provide something from a government entity, which could be a police report, a conviction, could be an order of protection, an injunction against harassment, but it could also be a victim. Victim advocate letter. Let's say you've worked with a victim advocate and they've assisted you along your journey. Let's say it's you've stayed at a shelter and you have a letter that confirms that. You can provide that. If you've worked with a religious council and they've assisted you with your victimization along the way, maybe safety planning or something, you can provide that. Just something that provides just documentation that this has happened. It's not like we're proving beyond a reasonable doubt. We just need something that documents the victimization type.
That's good to know. So the ways a person can qualify for this, become eligible, it's not simply if the offender was prosecuted and there's a conviction in place. It's really a wide range of being able to say, listen, this is an issue. I've relocated. I'm willing to meet with the personnel and go through this because I want to be safe. I mean, that's the bottom line. I want to be safe.
Right. And one of the key components when meeting with an application assistant is that the application assistant will go over the eligibility requirements of the program and that they safety plan with the applicant, because it is so important that applicants understand that this is just a tool to use as part of your safety and not intended to be a safety plan in and of itself. If someone enters our program thinking this is your safety plan, it's going to cause unintended consequences to that. Because
does someone's immigration status make them eligible or not eligible?
Don't even ask.
Okay, so that is not an issue, listeners. That's not an issue. The criteria, the eligibility is based on whether you believe you're a survivor of the different categories that Mary has outlined, whether you have either recently relocated or intend to relocate very soon, and then of course that you meet with one of their application assistants, have that
I feel like something's missing still.
in-person meeting. So immigration status is not one of the eligibility factors.
And then you have documentation to support your victimization. If you already have it, it's going to be a little easier because some application assistants aren't able to provide that documentation themselves. So if you can bring it with you to your meeting, that would be better.
Understood.
Some application assistants can provide it, just some can't.
I still feel like something's missing. What is it?
And you have to be in fear for your safety.
Of course.
You wouldn't be enrolling in a program such as this if you weren't in fear for your safety.
Yes, you would.
What?
Oh, absolutely you would enroll in this program because you would, if you would need proof that you were scared of something, I mean, fake proof, you know what I mean? Like if you were like a psychopathic lady who watched YouTube videos and thought that somebody else was making videos about her personally whenever they're made for the whole world to see. And yeah, so that would happen. Anyways, Shannon Walker, you can go fucking eat shit. Matt Walker, you can go watch your wife eat shit and then kiss her so you can get shit in your mouth. And y'all are all pieces of shit, dude. Have fun being shitbags. Like I said before, Matt, Shannon, y'all, the Walkers, you guys are fucking traitors, dude. You use the American justice system and the victims' rights and dude, you guys are scumbags, dude. Like, you didn't need to do this to him. Y'all are fucking, God, I can't say the things I want to say on here legally. So you see, by forcing him to file a motion and go through the state, you are, his 6th Amendment and I think 14th maybe, are just being fucking stomped all over. Like, and this is their regular practice. This is what he said. If you want to do it different, no. If you want to do it different, if you want to do it right, you can do it right in this case. But they're fucking everybody. That's what I'm saying. They're fucking everybody. You may not seem like much when you're locked in a cage. Little things like that may not seem like much, but those are huge. Those rights are huge whenever you're defending yourself against somebody. And it's obvious to him and to me that there's no possibility of a fair trial and of having a equal opportunity to defend himself like the prosecution has. And it's little things like that, and that just proves it right there. Even the state bar is an evil organization, but even they say that if that information is detrimental to if it's so precious that it needs to be hidden and it's part of the case, then it needs to be disclosed because it's equally as important to Mr. Myers. And what's funny is it wouldn't be. The only reason it is important now is because they made it such a big deal, right? And because of that, I found a few things about addresses and hiding them and whatnot. But I just want to explain that Mr. Myers, he sees all these angles. He knows more than double the shit that we all do. So he can see the future. He can see the fact that he is not going to get a fair trial. And so taking a plea is not bitching out. It's not. Even if he didn't know that, I would have it. Well, I still don't like that he did it. I'm actually torn up inside that he did because I wanted him to. I didn't even think there was a chance that he would do that, but he's got shit to live for, you know what I mean? But anyway, it don't matter what I think, but I'm just saying he knows what's coming up, and seeing these patterns of behavior from these people and their just lack of, they just cannot figure it out. Like, and he just weighed all that and decided to take it. That's fine with me, but I just want you guys to realize what's going on, that like, it is not fair. Like there's no chance, not because he's in jail. Like, again, he could do it without a pen and paper. He could probably do it without the law library. Those are things, again, those are rights that are taken from him, but you know what I mean? But the chance at getting another evidentiary hearing is absolutely 100% in the best interest of justice if they want to have a fair trial. But not being able to get that, and then the judge just completely disregarding any law or rule of disclosure, he's fucked. You know what I mean? He really cannot do anything. And then when he got in front of another judge, Lewinsky, oh my God, that was a fucking whole debacle. Like, and she's still in the trying to prove. She's still in the prosecutorial mindset, dude. See, I know this to be true, but most people just don't really get it. But what Lewinsky was trying to say is a fact that Mr. Myers needs to say out loud and admit to is actually admitting and giving the last piece of the puzzle to an actual crime for probable cause. That's all they need. That would have been part of the probable cause, would be that she feared for her safety. And then the reason, I don't know, like there was a dead body on the ground or whatever, and then there'd be a bunch of evidence saying you put the dead body there and made it dead. You know what I mean? Like, her fearing for her safety is a part of probable cause, dude. And they're still trying to prove it, like at basically at sentencing, or I mean at conviction. You know, like what would be? Dude, this is crazy. They're crazy. All right, let's go over this one more time, Rachel. What do you need to prove your point, or to prove him guilty?
Encourage his followers to contact her work address, her work phone number, and then he would put it onto his YouTube page, and then he put it up there, and he would encourage his followers to contact her.
See, what we're about to do right now is what Brendan and Weiland should have been doing in their hearings, right? But they're so hyper focused on getting, you know what I mean, fucking people over that they can't. But so we're supposed to decide if there's reasonable evidence of what Rachel is saying, right? Because this is what they're alleging, right? So the very first thing, he gets on YouTube and encourages his followers, right? Again, this is just absolute psycho bullshit that we have to actually believe that there are followers on YouTube, right? This is just retarded. There's no followers on YouTube. You're not following. You're subscribing to somebody's channel for information or news that they publish onto it. Okay, number one. Number two, how can you make a knowingly, intelligently based decision if you believe that they're followers, right? Because the word followers implies that, like on Facebook, that you accepted a request to be a follower, right? So, like, if you want to be a friend on Facebook, you accept a friend request, right? Which puts you in a group, basically. Like, it's again, that takes you from the surface web to the whatever, the murky web or whatever, where you have to have some kind of approval to see what's there. You know what I mean? You can't Google something and see something on my Facebook page that somebody in my inner circle posted on there. You know what I mean? You have to wait for I have to accept a friend request from you. You know what I'm saying? So that in itself is consent, right? So if you were to harass somebody under those standards, a Facebook standard, yes, because it would be personal, because you would have accepted their friend request, and you know what I mean? You're on a level where what you're saying is so personal that, you know what I mean? Okay, you get it. You keep saying to his followers, but it's not. Those that's a lie. It's to the whole world. He told the whole world to, if he did, which he didn't, but if he was saying that message that she says encouraging his followers, well, she's wrong. He was encouraging the entire world that can view Facebook, any viewable possible person that can possibly see it, he was encouraging them too. So how can you narrow it down to his followers? You can't. That's wrong. So that being said, even if you could narrow it down to his followers, you still got 15,000 more to go. But even narrowing it down to that, it's the whole world, right? There's no way you can possibly say that it was one of his followers. The only way to get that information is to get a hold of the person who left the message and have them admit it, or see if it came from their phone or their caller ID or whatever. But either way, you still have to know who left it. And that's why Brown sinks their case, because in Brown, the cops grabbed his caller ID, grabbed her caller ID, and matched them up with the times that she said they were, and it would all matched up. You know what I mean? Oh, right. Okay, now I just remembered. Some of y'all are thinking, you're like, well, where'd you get that recording? How do you know that she knew about that recording from a year ago or whatever, about the addresses and whatnot? Well, because it's on Matt's famous, it's on their favorite webpage, dude. The APAC, APAAC. That's where I got that recording from. And guess what?
We continue to put out her information during this time and causing those followers continue that contact with her. So he had initial contacts with her where he left her that message. He went to the law school looking for her, but then he also would use his social media to encourage followers to continue that contact.
Do you understand that all of that would have made her fear for her safety?
Oh, yeah.
How the fuck could it? The confidentiality program that we just heard says that it gives her a real fake address. So it's a fake address, but it comes back, even federally, it's going to come back as one that's legit, right? So what if all Mr. Myers followers get that address? It's all 15,000 of them are going to go to a fake address. How could she possibly be scared? If only we had proof that she and the Arizona, college university were aware of this. If only there was some proof of that, right? If only we had that proof. Well. Look what we have here. Here's the question of Mr. Myers' existence. Do you think at all that would make her feel for her safety, right? Would it? I don't know. After hearing this, no, right? But guess what? Like I've said before, officer safety is out the window. It's all about victims' rights and victims' safety.
Me and Chubb Rock combined weights. I love myself, I'm so vain. I'm not just the king of New York, I'm the king of the whole game. Putting rappers in hibernation, they're hiding away to retirement, they're racing. It's funny like a pie in the face and devastating. Made a mistake and you waiting, debating, facing your fate and creating, hating, raping, imitating, degrading, breaking your place and taking your safe and taking your paper, paying for faking. This is history in the making, but wait, spit at the cops, I'm resisting arrest. They wanna see me fry like a chicken wing in the breast. The truth is behind closed doors, I'm a bit of a sissy, singing love ballads to bitches like Lionel Richie. No joking, bragging and boasting, hoping to get close and approaching, poking, perping, imposing, potent poison, the potion, cooking the coke and cutting your throat, and opponent opposing, leaving you floating the ocean. You was a Leah rocking the boat and leaving you broken, get smoky the second that emotion explosion of flowing, overdosing the chosen.
I'm feeling so groovy now. Arguments full will fuck your whole head. I'm feeling so
Let's
groovy
begin it
now.
like this, the definition of a rap flow. I'ma reinvent it like this.
I'm feeling so groovy now. Arguments full will fuck your whole head. I'm feeling so
Let's begin
groovy
it
now.
like this, the definition of a rap flow. I'ma reinvent it like this. Yo, rat-a-tat, sporadic attack, panic, laying you down like crap addict. You dissing, missing your fingertips, you crack addict. I had it, I'm back at it, the mathematic, bringing the black magic. I pack, hold up, let's slow it down with these raps. Let me catch my breath, let my brain relax. I'm so fly, I'm basically levitating. I'm in the Guinness Book, record breaking. Hit you with a chair like the World Wrestling Federation. I got a bad reputation. Doc wanna put me on a better medication. Cops hate me, harass me, interrogation. Cops hate me, harass me, interrogation. Cops hate me, harass me, interrogation. Cops hate me, harass 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 me,